Oh, that's a good song for a mediation session. Come together.
Please welcome our mediation panel with certified mediators,
Wonder if
Jonathan
that was
Frank,
intentional.
David Hansma, and Bill Winsten, with E. Powell Miller moderating. This roundtable focuses on mediation and negotiation strategies in business disputes. Again, please feel free to contribute to the conversation in the media chat box.
I think we're ready.
Great. I'm happy to start. I didn't know I had the green light. First, I want to thank Mark Rossman for putting this together. I've spent decades in the shareholder oppression space, and I know Mark Rossman is at the very top of our profession. I don't know of anybody more knowledgeable about shareholder oppression law, and really appreciate the hard work you did, Mark, to put this together. I'd like to start with just a few introductory comments about mediation and negotiating strategies. First, in my experience, and I have done, I'm sure, hundreds of mediations in Michigan, all over the country. And my experience is that mediation tends to be underappreciated and under-resourced, given how important it is. I mean, how many times have we all got a mediation summary late, or sometimes prepared our mediation summary late? I sure hope that that hasn't happened in my firm now in many years, because about, I'd say now 7 or 8 years ago, I remember calling a firm meeting and saying to everybody, we have to understand that mediation is one of the key events in the case. It's often outcome determinative. It often succeeds and settles cases. I've seen mediation successful on the first try when no one ever thought in a million years the case would settle. I've seen it take 6, 7 mediation attempts. In some of my MDL class action cases, as many as a dozen mediation sessions before a case settled. And in my view, it needs to have the same importance as briefing a motion to dismiss or a motion for summary disposition. It's well worth intensive resources. And I think it's really important that when going into a mediation, everybody understands the interests of all the parties. You can't settle a case without appealing to the self-interest of your opponent. And it's very important to understand what your opponent's self-interest is. I've also learned that managing client expectations is vital to a successful mediation result in terms of whether the case settles or doesn't settle. And just as importantly, whether your client perceives you did a good job in obtaining the settlement. Without managing client expectations, you might obtain an outstanding result for your client, whether the defense or the plaintiff, but the client doesn't appreciate that it was a great result. So one of the practice pointers that I would offer is it's our policy before a mediation to bring the client in for an in-person meeting. Sometimes we bring experts in too. And the purpose for that is to make sure that the client has realistic expectations. And the way I like to define that is I view our job is to help the client understand as best we can and as best we can handicap it, what is the realistic best case that could be achieved in litigation, with emphasis on realistic, because there's lots of things that aren't realistic, as well as the realistic worst case. And if you define those goalposts, a reasonable expectation is to settle somewhere in between those goalposts. And I would say in my experience, 80% of the time, clients are too optimistic. And in those circumstances, really in all circumstances, I want my clients to make sure they read my opponent's mediation summary, that they understand it, they digest it, so that they don't walk into a mediation only reading our summary and having sky-high expectations. But what I've also learned is that 20% of the time, clients will have negative expectations. Maybe they are afraid of litigation. They don't understand the litigation process. And they're either too willing to settle for too much if they're a defendant, or too willing to take too little if they're the plaintiff. Both are obviously very serious problems. And I think it's important to understand the interests of our fine judges. I've never found a judge who would ever say, don't settle the case. I mean, their performance metric, it's not their job to get a good settlement for either party. Their job is to encourage resolution of disputes. And so if it's a mediation where the judge is present, I always warn my clients that, of course, the judge is going to lean on you to settle the case. I urge you to rely on my judgment as to whether you should accept an offer or make a different offer. Same thing with mediators. Most mediators view their job as to settle the case, and they're going to put a lot of pressure on you to settle. I love that interest when I have a client with unrealistic expectations, but I worry about it when I have a client who might be a nervous Nelly. And I try to prepare those clients to understand that the mediator is, of course, going to push you towards settlement. That's what they view their performance metric as.
Powell?
Yes?
Powell, can I make a point on that too?
Of course.
And when I mediate a case as the mediator, I like to talk to the attorneys before the mediation, just the attorneys, separately, one call with plaintiff's lawyer, one call with defendant's counsel, because I want to talk to them, not in front of anybody else, so that they can tell me those dynamics, right? What do I need to know to help settle this case? And in particular, what do I need to know about your client? It's not very helpful for you to come in and say, you need to tell my opponent that they're going to lose this motion and they're going to lose this issue and I'm going to prove this and I'm going to prove that and their case sucks. That's not entirely helpful. I mean, it's good to know those things, but what's more helpful is for you to say, here's the issues with my client. Here's the psychology with my client. Here is, where I think my client is going to be realistic. And here's where I think my client's going to be unrealistic. And, I need your help as the mediator to help my client see reality. And to your point that you were making, I think it's really good, Powell, that you have a meeting with your client to tell them, to discuss reality, because I think a lot of clients come in not having had the reality check. And as the mediator, no case is going to settle unless people see reality. But as the mediator, we don't want to embarrass counsel by being the first person to tell the client that their case isn't as strong as they think it is. But,
David, I agree with you in 80% of instances, but I found there's 20% of the time where I have a client who's got a great case, but they're not confident in their case. It's early on, and they're afraid of litigation, and they're too quick to want to give it away. And when in that kind of context, if you're the mediator, I'm going to be very, very guarded in that initial call with you, because it's my job to protect my client, sometimes from the mediator, because the mediator is going to push my client to settle the case, because that's viewed as the performance metric when it's not in my client's best interest. And in that context, I'm working really hard to increase my client's confidence in their case and to have trust in me, not the mediator, because the mediator's job, of course, is not to advocate for the client. That's our job. So the mediator's job is to settle the case. So
that's good information for the mediator to have, because I would like to know going in, why is Powell treating this mediation like it's the trial? Why is he being so, pedal to the metal on the merits of his side? And knowing that you're doing that because your client is a little bit, willing to give up more than maybe he or she should, that's helpful information to have coming in, I think, as the media.
Yeah, I think also, Paul, the main thing, and I do the same thing David does, I'm sure Bill probably does too. You have that conversation, and I talk to you, Paul, and you say, I have a nervous Nelly. That's a good conversation for us to have so that I know what your outlook is and what your client's outlook is. If you say to me, I have a client who's got the most crazy expectations about the value of this case, I haven't been able to talk to my client to get them off the ledge. They think it's worth so much, I'm going to need your help. That's good for me to know too. And what I do to help out during the mediation is I present to the clients the idea that your job, Powell, or any lawyer's job, you're wearing two hats ethically. One is you're a very zealous advocate, but you also have to give your client frank advice that may sound like you're not so much of an advocate. You're not the gladiator. And if they hear from me some things that maybe you wanted me to say, I think we work in tandem on those clients. And I think the pre-mediation call is an excellent way to find out where you think I can help you.
100% agree in most cases, but I'm talking about the exception. I have definitely had cases, sometimes representing an organization where there are some people who have a realistic appraisal of the case and some people who don't. Now, obviously, we follow our clients' directives, whatever that may be. It's their case. If they choose to settle it for less than it's worth or to pay more than they should, that's entirely up to them, not our job. But I have just learned from many years of experience that sometimes I have to protect my clients from very good mediators who are good at reading who is the weak person in the room and then taking advantage of, and not in a bad way, I don't mean this pejoratively, don't misunderstand me, but I've seen very good mediators who view their performance metric as settlement, reading who's the weaker person, exploiting that and getting a settlement. And if I think that's not in the best interest of my client, I'm going to have a very open and honest conversation with my client before that mediation,
right?
So that they're within those goalposts.
Let me throw it over to Bill
Sure.
on that issue to be the tiebreaker. Not really, but still, because my sense is, Paul, that my job is to kind of pierce you a little bit, because maybe there's an interest your client really does have that is like Bernie said, what is the client's real expectation? Do they want an apology from their dad? Maybe that's really what they want. And maybe the lawyer has been pushing them towards $1 million and what they really want is just an apology from their dad.
Well, I think what this discussion shows is that one size does not fit all, and that you need to be flexible and to adapt with respect to a mediation. I think as a mediator, it is critical, particularly in the morning, that you hear each side out. You need to understand their position or grievance. You need to make sure that you get their situation, that you're empathetic to their situation. You need to build trust. That's incredibly important for the morning. You need to be flexible how to proceed, as I said. You need to, on both sides, point out the uncertainties and the stuff that can happen during the litigation that could be harmful to each of them. And you need to understand the change in circumstance that typically has occurred that has caused the litigation. The oppression cases fit various patterns. Is it the original investor who was critical then, who now is getting paid a lot of money, but isn't contributing anything, and the people operating the company don't want to keep paying him? Is it a dispute between the original founder and the person who's grown the business? Is it a fight between siblings or generations of relatives? Is it a change over time in who's doing the work, but the shareholder agreement still has a kind of a fixed relationship? You have to figure that out. And then you got to change the dynamic. People come in with, or try to change the dynamic. People come in with some pretty set views as to outcomes or dollars involved, that kind of thing. And you have to do what you can to raise some things that they may not have fully internalized, that may cause them to view the case differently. For example, if you're the majority and you're alleged to have oppressed the minority, but you have a bank loan coming due, and you need the minority as a guarantor, and the bank's going to want the minority to re-up on the guarantee, you may not have the ability to finish the case because that minority is going to have a lot of leverage over you coming up. So you got to, look at those. That's just an example, but look at those kinds of things. And I think it's very important early on not to be too judgmental, to not embolden the intransigent, somebody who's relatively intransigent, and be relatively gentle with them in the beginning. Afternoon, there may be a lot more tough love. And I think it's very important to support the attorneys and to reinforce to each side that they have a good warrior for them. But here are some issues that you need to consider. I'm also not a big fan of exchanging offers too early. Both sides almost invariably are way too hard on those issues. What I prefer to do instead is, at least in the beginning, ask each side to confidentially tell me where they really want to end up, so I can figure out where the goalposts are. Obviously, they're not going to tell me 100% what that answer is, but I think that's much better than asking them for an offer. I don't communicate those goalposts to each side, but it helps me understand how to proceed going forward once I know how large the gulf is.
So,
Yeah.
Bill, I'm curious.
Bill, I gotta say, I completely agree with you. I've become stubborn about it. Lawyers will want me to pass along an offer. I know it's just going to inflame the other side. It's just going to. I mean, if they had an offer that was reasonable, they would have settled the case already. So my goal is to hear both of them and kind of digest what they say, and then figure out how I can explain it to each one. I'd be curious to know if any mediator or any lawyer who's done a mediation of a business case feels like it's a good idea to put a really hardline offer out on the table early on. I've never seen it work.
I would say not in an oppression case, certainly, maybe in something more straightforward like a breach of contract, but in a complicated case like a shareholder oppression case, especially, we call them business divorces, and the emotions are usually running about as high in a divorce case. And typically the opponents loathe one another. Any number that comes out at the beginning is just going to be seen as an insult, whatever it is, right? Because the emotions are running so high. And that actually, I wanted to get back to, just briefly, if I may, something Bill was talking about. At the beginning, as the mediator, I think another role the mediator has, because sometimes I'm not sure counsel, and I will confess to not doing this myself, always do a good job of getting their clients to buy into the mediation process. A lot of times they're there because they're ordered to be there by the court. They don't want to be there. They don't want to negotiate. Why should they have to give up anything? Why should they have to concede on anything? They're right. Their opponent's wrong on everything. This is a waste of time. And it's not that. It shouldn't be that. It's the party's opportunity to reach a business resolution of their case. And, I think most of the time mediators are trying to get their clients, or get the respective clients, to see that and understand that. And like I said, I will confess, as a litigator representing clients, there have been times where, I probably haven't done as good of a job as I should have getting my client to buy into that process before we show up at the mediation. And that's something that you then have to try and overcome in the morning of the mediation. And that's really not the best way to do it.
I think that goes back to the point about preparing your client. Powell, you mentioned, managing your client's expectations. And I think it's important for the lawyers who are listening to this, who are representing clients that are about to go into a mediation, to really have a firm conversation with them to outline what it's going to look like, prepare their expectations. I would even suggest explaining the logistics, like what is the mediator going to say right away? Are they going to talk to you about confidentiality? Are they going to put you in separate rooms? How are the caucuses going to go? Because you have business people that aren't familiar with the process, and they need to be. It's like going to a doctor's office. If you can say to somebody that's about to go see a cancer doctor, when you show up, you're going to see the receptionist, you're going to see the doctor a little while later, maybe longer, et cetera. It puts the person at ease when they show up and it really happens that way. And I would suggest to any lawyer that's putting a client through mediation, talk to your client as much as possible about what the process looks like. It'll relax them. You need them to be relaxed.
So I'd like some thoughts on what people think are characteristics of a good mediator as compared to one that's not so good. In my experience, I have seen some wonderful mediators, and I would definitely put Bill Winsten at the top of that list. And I've seen some mediators who are like considered famous mediators outstate who I was extremely disappointed in. And so I think choosing the right mediator is very important for every case. So what should folks look for?
I think you have to have somebody who's a good listener, first and foremost. If you have somebody that's aggressive and feels like they can dominate as the mediator and tell everybody what to do and not be listening to the cues that you're getting from the participants, you're going to have a bad mediation. And it may be people you're talking about, Powell, that have a big profile or whatever, and you have to have your ego down as the mediator. I think that's the most important thing. You have to be able to take everybody's point of view and massage it and play it back and reflect it and see where you can bring people together and not dominate the conversation.
Yeah. I'm going to give an example of a bad one. I'm not going to mention the name, but it's a world famous mediator based in the DC, Virginia area. And what this mediator would do is comes in always with an assistant. So you're not just paying for him, you're paying for the assistant with 2 laptops. And whatever you say, you just hear these 2 laptops going for 10, 15 minutes. And all he does is then go to the next room and do the same thing and ultimately just exchange numbers. I have found that to be the worst mediator. The characteristic that I look for, I'd say, are 2 things. Listening, I agree with you 100% on that, John, but it's really understanding the case and rolling up their sleeves and knowing the strengths and weaknesses and being able to articulate those strengths and weaknesses and being determined. I mean, I am so appreciative of mediators when a case doesn't settle that will call a couple days later or a week later or sometimes a month later, because those mediators understand that sometimes sides stand on ceremony, excuse me. They don't want to appear weak, but a good mediator will stay involved. Bill, what do you think?
Well, I think that the key to success at a mediation, especially in a business divorce case like an oppression case, is each side has to feel that you get their case, you understand their case, their points have resonated with you, and because for them this is their day in court, typically, and without undercutting that you understand it and you get it, you just need to point out things that they ought to take into account, which should cause them to focus on why it makes sense for them to buy out the other side or whatever the appropriate resolution is. And you need to get them there. And there are, frankly, incentives for the oppressor to buy out the oppressee. There are incentives for the person alleging oppression to get a check and go home. And you need to kind of focus on what the weaknesses are in their position without putting a dagger in their heart, but pointing out how it could all turn to manure for them. And therefore, what maybe you can get on the table for them is a lot better than the abyss of litigation and all the uncertainty that goes with that. So I think if you can establish credibility with them in the morning, by the afternoon when you're making these points, they're going to resonate with them. And you know, the vast bulk of these settle. And by the way, that the nationally known mediator, Powell, that you have, I'm sure most mediations don't go one day because you can't get it done in 1 day.
You got that right, Bill.
Bill, the interesting thing about that is, how do you do that? I mean, the skill of being a mediator is to read the room, right? So you have to be perceptive enough to be able to say to somebody that feels bullied. Let's assume you have a minority in a family, they feel bullied, maybe since they were 5 years old, by the rest of their family. So how do you empower that person during the mediation to feel like, I get that, you feel bullied. This is your chance to be on equal footing with the rest of your family because you're in the court system. So you have some power. And then you say to the bully, listen, it seems like the problem you're having in this family dynamic is this brother, whatever, feels like they've been bullied by you. And I've put it directly out on the table because I think it's effective to acknowledge the kind of underlying source of tension. But you have to do it in a way that doesn't sound like you're scolding, right? That's the hard part.
So I have a negotiating strategy question, and our experienced mediators, I'm curious what your views are on this. Whatever number, say, a plaintiff gives, I'm sure you think that number is obviously inflated. How much do you discount it by? Is there a rule of thumb?
No, don't let David start. We've been talking.
Go ahead, David.
I wouldn't say there's a rule of thumb. I think the more important piece of it is whoever makes the opening demand or opening offer, that the other party understands that it's just an opening, and that no one sitting in the room, including the person making the offer, really thinks that that's anywhere near what the case is going to settle for. So don't be put off by it. Somebody has to make the first move. This is what it is, and now let's go from there, rather than getting worked up by, why is plaintiff's demand so high, or why is defendant's offer so low?
David makes a good point. Sometimes I'm the one that makes the first move. In other words, I have not exchanged offers, but I've listened to each room, have a better understanding of what their confidential positions are. And what I then do is bring the lawyers together, say to them, look, this is not going to be a surprise, but each side is very unrealistic in terms of what they think should happen here. I think if we're going to have a productive mediation, we need to get on a playing field that makes sense here, given the case. And I propose brackets. I say, if both sides say yes to the brackets, we're going to continue. Anybody wants to reject the brackets, we get to go home. And you have to be very creative on how you set the brackets, because you've got to set them where you narrow the dispute, but they're set also at a level where you have a reasonably good chance of getting both sides to say yes. There's an art to that. And of course, on the brackets, you have them each confidentially come back to you and give you their answer. And you only find out the other side's answer if you say yes. So nobody needs to worry about setting a new floor or ceiling. But brackets can be very useful if you have unrealistic expectations, because now, on both sides, because now, if they say yes to the brackets and the other side says no, the other side didn't know that they said yes. But if your brackets are reasonable, you've now moved it into a much better discussion.
What I've coupled with that is a kind of a cross-examination, and Bernie mentioned this in the last session, which is you have to be able as a lawyer to cross-examine your own client. And I think in an oppression case, especially where there's so many moving parts, the lawyers have to appreciate that we may cross-examine their client, we may need their help. And to follow your point, Bill, if you're going to do that and you find that the underlying foundation, the building block of a particular side's demand or offer is, and I just did one where there was an overcompensation issue by officers. Well, that became a fundamental issue in the mediation, and it turned out there were some misperceptions of the underlying facts and some of the expert testimony on that issue. Well, if I can cross-examine gently and say, hey, you're really relying on this overcompensation issue, but did you consider maybe that your expert overlooked this? And now they're not really backing off of a position just arbitrarily. They may back off because they realize, that's right. We went too far on that point. But again, you have to be careful that you don't sound like you're coming in the room and blowing people up about it.
I'd like to raise one thing about virtual mediations, given the world we're in now, including virtual symposiums. I've done several virtual mediations over the last, during COVID, and there have been some, my observations are, my concerns with respect to virtual mediations have not panned out, but I had the wrong concerns. My concerns were that I would not be able to read people on a screen, and that I would not be able to build a rapport with people. Fortunately, both of those have proven untrue. I think you can read people on the screen, and I think you can build the rapport. What I did not expect, and what you have to account for, is that because it's virtual and people don't have to travel, you frequently get a lot more people on each side participating. And so you have more hawks maybe in the room than you might ordinarily have. And because you're not sitting in the room or across from the client and looking at the client when you ask a question, where it's clear the client's supposed to answer, I find the attorneys are much more active, or try to be much more active in the virtual mediations, and you have to find a way to defeat that. I apologize. And so, you know, sometimes it's, you know, Mr. Client, what do you think about this? As opposed to just saying, what about this? You need to make sure that you get the client talking as much as possible, and that the attorney doesn't front for him or her more than you want them to.
Just asked about creative tools that can be used in a mediation. One thing that I've done sometimes as a litigant is where both sides clearly have confidence in the mediator.
Powell, can you speak louder, please?
Yeah. When both sides have confidence in the mediator, but progress is not being made, suggests that if the mediation is not successful, the mediator becomes an arbitrator. And that does two things. One, now everybody better be reasonable, because now the mediator has the power over everybody, and that sometimes brings people closer together. And second, if everybody has confidence in the now arbitrator, even if you don't settle it, you hopefully have a faster path to resolution. Bill or David, you have any thoughts on that?
I have not done that specifically. I've done it where you do your, you know, written settlement agreement at the mediation, and then where you agree that the mediator will arbitrate any disputes when it comes time to formalize that into a more formal document. If there's a dispute over, you know, what did we really mean by this short memo of agreement? I've done it where, well, the mediator will arbitrate that issue and things like that. I've not done it where the mediator would arbitrate the merits of the case, which I think you certainly would have to have confidence in your mediator to do that. You know, there's reasons judges don't get involved in settlement conferences where they're doing a bench trial, for example. So, you know, you need to be careful, I think, as the advocate about, do I want this person who I've sort of disclosed the skeletons in my closet about my case to now decide my case?
Yeah, there's a lot written about that. And the real concern I have on both sides, either as an advocate or if somebody asked me to do it, is, you know, that once the mediator hears the settlement positions, it's like what you were saying, David, about a bench trial. So once the mediator hears the settlement positions, and now you're saying to the mediator, we couldn't work it out, so please arbitrate. Well, the natural human instinct is to find a number that you feel like you're not going to make anybody pissed off at you. So even if you in your head think, all right, I'm moving now from my mediator hat to my arbitrator hat, and I'll just look at the facts and everything like that, I think there is some of that underlying sense of making everybody satisfied. It's a it would be a challenge.
I think that's especially true in oppression cases, especially oppression cases that are being arbitrated. If you've got a case that goes all the way through trial, these people that hate each other in a business divorce, regardless of the relative legal merits, I think any arbitrator is going to be tempted to separate these people, regardless of whether or not the conduct really meets the technical definition of oppression. We've just got to get these people apart. I think there's a
no-fault divorce proposition.
Yeah, exactly. And so I think, and that's something that you can use as an attorney when you're representing a client, is to, especially if it's in an arbitration context. I think there's less risk in court, probably more in arbitration of this. If you're representing the defendant, you can tell them, look, there's a lot of risk here that regardless of the relative legal merits, the arbitrator is just going to want to separate you people, and you're going to be buying your partner out. And when you're representing the plaintiff, you can kind of give them the reverse of that. You know, the arbitrator is going to be tempted to just separate you, but the price you're going to pay for that is you're not going to get the number you think you're going to get. And so you both have risk.
Again, I think the whole key is, finding common ground any way you can. I'll never forget one I had, big case where Tom McNeil was my opponent, excellent lawyer. We had, I guess that when I said the guy in DC was the worst mediator, this guy probably beats him, based in New York. And we were at 3 expensive mediation sessions going nowhere, going backwards. And on a hunch, I called up Tom and I said, Tom, this is an unusual mediation. The mediator keeps telling my client how great his case is. I got a hunch that he might be saying the same thing to your client. He said, he sure is. I was like, oh my God. So we both agreed to discharge the mediator. That was our common ground. And Tom and I sat down and figured out a way to settle the case. So.
Let me just jump on something Bill said, because I think it's a wave of the future in terms of Zoom. I agree with everything Bill said in terms of my fear that and not being able to read the room, but you can do it and you can establish a rapport. There's a big value in what's called asynchronous mediation, which is I can have people sitting in their office from 9 to 10. They don't have to come to my office. They don't have to sit there all day. I can go to the other side from 11 to 12, and they don't have to be sitting waiting for me between 9 and 10. And then I can say, you break for lunch, but not the other side. I'm going to talk to the other side while you break for lunch. And there's a huge advantage to doing these by Zoom. I'm still going to spend the full day, but the parties, especially business people, can sit in their offices. They can get some work done. They know that I'll text their lawyer and say, all right, come back on the call in 10 minutes or 5 minutes. And they don't have to be wasting a whole day. And I think that's something that even without the pandemic, I think we ought to consider doing.
And I do think that even if it's a virtual mediation, especially in an oppression case, it is very important to see if you can create a binding term sheet that people sign by the end of the session. What I typically do is while the session's going on, I'm working on a term sheet. Obviously, it has some blanks in there. But and it says at the end that it's a binding, while the parties may contemplate a more comprehensive settlement agreement, this term sheet is binding and enforceable without regard to whether they ever enter into that, so that there's a deal, because these people have been fighting, and it can all fall apart if you let them leave the
don't let them leave
the ambiance of the mediation. So yeah, another thing you can do to change the dynamic, given the recent Court of Appeals decision in Michigan, is discounting of fair market value is now in play. So from the oppressor standpoint, from the plaintiff standpoint, that person's at risk that they're going to get substantially discounted because it's a privately held company with no market. And so, and then the oppressor can turn around and sell the company the next day and make the spread. The contrary is true with respect to the oppressor. They may end up paying full freight market value as determined by Tom Frazee in his very aggressive analysis of what the market value is. So they're really, the benefit for the oppressor in settling it is if he can get a price he can live with, and maybe even that price is not very far off from what he's been paying the person every year. And he's just spreading it, and he's taking the money he would have been paying them and cashing them out. So, there are lots of benefits to doing such a deal.
Does music mean we're supposed to be done? Is that what that means?
It's like the Academy Awards, David. I think that means they're taking a commercial break.
Yeah, I think we passed the baton now. Thanks,
right.
David, Bill, and John.
Thank you, everyone.
Great job.